Alright, I decided to make a video of, what the 7 things employees and executives must know about FTC and the ban of non-compete. So, if you didn't know, the Federal Commission has issued a final ruling banning non-compete arrangement for employees, independent contract, and executive employees. So the ban becomes effective 120 days after the date of publication of federal registration. That's May 7th. So 120 days after that, and will schedule to take force in early September, which is about to come. Now, however, before you get excited at the end of non-compete, be aware that the matter is far from being settled. Legal challenges are being going on, and the final rule detail release has been ruled whopping 570 pages. So if you don't want to read it, I kind of got these 7 steps. So how the FTC defines a non-compete. So the FTC defines it by the final rule defines non-compete as terms of or condition of employees that prohibits a employee from penalize a worker for or functions to prevent a worker. So for either taking a different job or operating a business after the end of the employment. So it's pretty much saying, hey, you can go work for someone else or you can start your own business. Now, the analyzed final rules for this by the Morgan Lewis assertive scope of a non-compete ban will include standalone non-compete agreements, but will also pick up many executive agreements, including non-compete covenants and equity grants, employment agreements, and severance agreements. Since the rule voided post-employment non-compete, the ban may extend beyond basic non-compete clause. So, for example, the stock option restriction stock utilities, it may prohibit any provision and stock vesting if you leave a work for a competitor. Now, exemptions to this non-compete ban. While the ban is fairly sweep, it does contain some exceptions. Now, not all non-compete is going to go away for executive, and this is one of the things you have to understand. If you're making more than $151,164 per year, and it's a policy making position, so you have to be making policies, and this non-compete doesn't go away. So you have to make what 151 more than 151,000 and make policy. So you have to understand if you're in that position, the non-compete still is hold against you. Notably, the difference in the border as senior executive, that's a big difference. In certain industries are excluded from non-compete. So they ban does not apply to non-profit organizations. So if you're a non-profit, the non-compete doesn't apply to you. It also carves out industries not to cover by the Federal Trade Commission Act. So banks, saving and loan administrator, federal credit union, common transport carriers, air carriers, and any individual business subject to Packers and Stockyard Act. So that doesn't apply to a lot of people, but it does carve a difference to it. So non-competes are still allowed. So don't think that non-compete are not still allowed. The rule does not apply to non-compete that are part of corporation, acquisition, or sale of business interests. So non-compete still is allowed in that industry. So understand that not all non-compete is going away. It's just the ones that affects people livelihoods, the people who needs to work with their skills. Now, number 3, your state law may still apply. So federal non-compete ban overrides any state's rule on non-compete that are weaker or at odds with it. So your state ban against non-compete and even tougher than federal ban, such as strict anti-non-compete rule in California, remains in force. So if you're in California, the rules still stay in force. So just because the federal said it does not mean that the stricter states like California they won't agree to. So that's different. So state law may still apply to you. Now, non-disclosure agreement may be restricted too. So you not or NDA or so the law firms believe that non-compete may apply to similar to worker arrangement, such as non-disclosure agreement. So you might not be able to tell them, hey, you cannot tell them about this deal, which is fair. You can't tell them about the product, which is fair, that is coming out. But if you're a service tech that works on it, you're not telling them you're using your skills. That's the difference. You can't take away your skills and hurt someone's livelihood. That's where the FTC is trying to say. So, function to prevent a worker from taking a new job. That is what they're trying to say. So if I try to go work for another company, they can't take away my functional skills because that hurts my livelihood. That's where it comes from. But they can say, hey, you can't come back and talk to these people for 6 months, you know, because you're taking away. Now, lawsuit number 5, lawsuit enforcing prior non-compete do not go away. So if you have a current lawsuit, it doesn't take it away from a former company. Now, the court to enforce the non-compete against you, the federal non-compete ban does not stop a lawsuit. So the FTC final rule states that the alleged breach of non-compete happened prior to effective date of the new rule is alleged can start or continue. So until September 4th, if you start going and start doing things against the company, they can go against your lawsuit because the law doesn't take effect until September 4th, 2024. So until then, do not do anything. That's something you need to understand. It takes away the non-compete after that, but during the case, you have to understand non-competes will be removed for workers. Number 6, what your company must tell you. If you have a non-compete, whether it's current or former employee, the company must inform you that the non-compete is no longer enforceable. So your company or your ex-company needs to give you a final notice, give you a mailing notice, say, hey, you're clear. You can't keep working. They cannot legally enforce it, so they have to tell you. Now, what they're probably going to do is send you a different type of letter and say, hey, but you can't do this. So that is what they're going to do. I expect to see one. So after September 4th, I expect to see one, and this is what the FTC says. This is not what the state says. So the FTC says, hey, you need to send them a mail saying you can no longer enforce your non-compete. Now, number 7, legally challenge will severely test the non-compete ban. So legally challenged to the non-compete ban's already underway, and they're already filing lawsuits saying, hey, you can't do this. And the more aggressive is coming from people who provide tax services and software is saying you can't use our software in another company. You can't do this. So is it going to take some time? Well, even if it goes to the court system, they challenge it, it's still going to take 12 to 18 months to play out. So before the Supreme Court makes another decision. So either way, it's going to take time. Currently, September 4th, all non-compete goes away, and companies needs to follow by that rule. Now, what are they going to do with it? Who knows? But my understanding is it's a good thing. You're going to get in the mail. You're going to be at home getting the mail. Say, hey, you can now go work for other companies. And that's a good thing. Now, I don't recommend you start talking to other companies until September 4th, and do not work on the equipment or anything like that until past September 4th, because that's what the law states right now. So if you want to read that 561 pages, I read it, and pretty much just tells you, hey, you can't stop people from working, and they expect a increase in businesses a year, and they expect every year you can get a better pay increase so that they don't lose their important employees. So you can get hired on at a basic pay, but they're going to make exception and give people more money so that they can keep them, to keep their good employees, and they wouldn't care about their bad employees. I guess is the best way to put it, but I believe it's a good thing so they can even out the workload in these companies, because currently they're not even out workloads in most of the corporations because they can't fire them. They have a non-compete. It's people's livelihood. But well, now more people is allowed to go to other companies, and people are gonna start competing for these jobs, and they're gonna be looking for these better employees. So it's gonna about open a job market for these really good employees and across the industry. So people are going to be able to start working for other companies with high skill sets and not be limited to staying at their current company. Now, this does not apply to banks and other thing and packing companies, so y'all need to be careful and talk to a lawyer or someone that actually know the law and not just listen to some YouTuber. Please like and subscribe to my video and stay tuned for more videos.